Good morning, everyone. Good morning, everyone. My name is Hussein Mahadi, and I'm the moderator for today's session on the FinTech Mentorship and Internship Program. Kindly indicate if you can all hear me, please. Good afternoon, Albert, Mr. Albert. Good afternoon, Amina, Oluwakami Kosano. Good afternoon and welcome to the call. We are waiting other. Please let's indicate if you can hear me so that I can proceed.
You're audible.
All right, thank you very much, sir. So as we all know, today is the 4th week of JIIPCC Mentorship and Internship Program on the FinTech program. And the topic for today's session is intellectual property protection of FinTech. And today we have 3 mentors with us. We have Mr. George, we have Mr. Albert, Ade, Adu, and finally we have Mr. Olarinwa Aluko. Those are our 3 mentors for today's mentorship program. Quickly, I will be making a few announcements before we jump also to reading our mentors profile and to taking presentations from both our mentors and our mentees. Okay, about the program, JIIPCC Mentorship and Internship Program for FinTech is a quarterly program for students and young professionals across Africa. Mentees are afforded the opportunity to access valuable advice, training, network, mentorship, internship, discussion forum, industry updates, and resource materials from experienced mentors. The program seeks to encourage continuous training, development, and evolution in Nigeria, Africa, and around the world. You can watch some of our videos on YouTube and other social media platforms by searching JIIPCC or hashtag JIIPCC MIP. Some of the objectives for the program is to provide easy access, guidance, training, and resource material for students and young professionals in Africa, to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders, to transform mentees into mentors and leaders for the next generation, and to facilitate further mentorship, internship, scholarship, and job placements for the mentees. We are also making an announcement to our mentees to take advantage of the opportunity of having a 30-minute one-on-one session with your favorite JIIPCC mentor. You can register with the link on your screen to get a private session with them on secrets, live lesson, directions from your mentors, and life hacks. And the second announcement is that JIIPCC is announcing that we'll be having 5 courses for the next quarter of the program. As we all know, JIIPCC is a quarterly program. So the courses that will be availing us with for the next quarter are entertainment, business and law, data protection and privacy, fintech industry, the blockchain, NFTs, our metaverse, and the intellectual property. So those are the 5 courses that will be offering next quarter on the program. I'll quickly be taking our mentors profile now. So we'll start with Mr. Albert Ade Adu. He's a results-driven lawyer with a pragmatic approach to advising clients on legal issues. And as a result, his team has earned several awards from the legal service industry and commendation from clients. He also possesses leadership qualities that afford the best from teammates, both in the course of executing clients' instruction and personal development. Mr. Albert undertook both strategic planning for personnel development and business development roles, which on occasion have merited him to winning the Lawyer of the Year award, the Year Prize. His expertise transverse arbitration, dispute resolution, legal writing, debt restructuring, mergers and acquisitions, commercial law, corporate restructuring, corporate finance law, FinTech and securities law. Mr. Albert is a graduate of the People's Fellowship University, Moscow, Russia, the University of Buckingham, the University College of London, and the Said Business School, University of Oxford. Kindly join me in welcoming Mr. Albert. Welcome to the call. We are very excited to have you on the call today.
Thank you
Our
for having
second
me.
mentor. Thank you very much, sir. Our second mentor for today is Mr. Folarinwa Aluko. Mr. Folarinwa is a legal practitioner and partner in the firm of Truman Rockwood Solicitors, where he provides advisory and consultancy service to companies and a wide range of creators, users, and startups. Mr. Folarinwa is the director of the Intellectual Property Institute, Nigeria. He is the chairman board of trustees of the Intellectual Property Lawyers Association, Nigeria. Folarinwa is a member board of trustee of the Sports Lawyer Association, Nigeria, as well as member of the board of the Nigerian Digital Chambers of Commerce. Mr. Folarinwa Aluko is a board member of the Songs Writers Association Nigeria with a background in ICT hardware and digital forensics. Folarinwa has a legal team on to champion consequential strategic impact public interest litigation in the IP space since 2012. Folarinwa is a consulting mediator with commercial intermediates in ADR firm based in Lagos and Abuja. He is a thought leader in Nigerian's innovation, technology, intellectual property, and entertainment space. Welcome to the call today, Mr. Folarinwa Aluko. We are very excited to have you here with us and also looking forward to learning from you today. And our last mentor for today is Mr. George Onyewuchi. Currently heads FinTech engagement for First Bank and its subsidiaries across Africa at its Digital Innovation Lab, setting up and driving the bank's FinTech strategy. Mr. George is a link that connects technology, business, and ecosystem partnership. He is at the intersection of product partnership and ecosystem building. He has led the tech solution product development for the SME banking business of a leading commercial bank and has taken numerous financial and non-financial products from idea to market and growth. He has led digital transformation in the client's engagement processes for leading commercial banks, including one of the Nigerian banking industry first end-to-end account opening for corporate accounts and SMEs digital lending. His team has won numerous awards for powering growth of SMEs. He also provides advisory for Quick.Africa towards developing blockchain infrastructure and building the operating system for African businesses on the blockchain. And hosts knowledge sessions on blockchain application to various industries within the African context. That's our last mentor for today. Kindly join me in welcoming all our mentors to the call. We are so excited to have them with us today, and we look forward to learning from them on the topic for today. Mr. Folarinwa is also on the call. Good afternoon, sir. We are awaiting Mr. George to join the call. So quickly, I'll call on the first mentor for today, Mr. Albert, to give us an overview of the topic and an introduction, a brief introduction for 15 minutes. Thank you very much, sir.
Thank you very much, Mahadi. I was wondering if I could share my screen with you.
Yes, sir.
Okay, thank you. Okay, the topic as I framed it is the role of intellectual property law in FinTech. As earlier mentioned, my name is Albert Adu. I'm a partner and head of FinTech practice group at Alliance Law Firm. And this is the outline of my presentation. We have the global spread of FinTech since its inception in around 2007, 2008. The role of IP law in FinTech, IP regulation in Nigeria, and then my conclusion. It's going to be a very brief presentation. So the global spread of FinTech. Statistics tell us that by 2024, the FinTech institutes collectively will be worth about $188 billion. As of 2022, it was 180 billion US dollars. And here we have a breakdown across the globe. North and South America, we have 10,755 institutions. Europe, the Middle East, and Africa, we have 9,323 institutions. Asia Pacific, we have 6,268. What this tells you is that FinTech institutions are growing every day across the globe. And the reason for it is there's demand. There's demand because of the value FinTech plays in the lives of ordinary citizens, wherever they may be in the world. And anything that has value, we know historically has always needed to be protected. I try to project that in this slide. If you see the picture in the bottom left-hand corner of the early man there protecting family, protecting what would be his house or his home, because, you know, those are things of value. When you move on to the other picture, top left corner, it's a fort from the mid-16th century. And you can see it is also fenced because it is valuable property. And then you move to the right, top right corner, you have the most famous building in the world, arguably, and you can see the fence there. So why is property always protected? Property has always been protected because it has value to man. And in the right-hand bottom corner, we have a picture depicting a man's thought process. You see, this is very intuitive and ties into this theme because intellectual property, as we will come to see, has to do with the creation of the mind. The role of IP law in FinTech. As earlier mentioned, if you look at the definition of intellectual property according to WIPO, the World Intellectual Property Organization, intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. Cornell Law School defines intellectual property as any product of the human intellect that the law protects from unauthorized use by others. Intellectual property is generally characterized as non-physical property that is the product of original thought. And that's from the Stanford Encyclopedia of Philosophy. We now look on the right-hand column for the definition of FinTech, which is a catch-all term referring to software, mobile applications, and other technologies created to improve and automate traditional forms of finance for businesses and consumers alike. And that's from the Columbia University. According to the US Chamber of Commerce, FinTech or financial technology is a term used to describe any technology that delivers financial services through software such as online banking, mobile payment apps, or even cryptocurrency. Corporate finance defines FinTech as a blanket term that can mean many different things. Broadly speaking, it describes the evolution of an industry where new technology use cases are developed and deployed to streamline more traditional looking finance functions. You see, when you take the definitions on the left and juxtapose them with the definitions of FinTech on the right, what we get is really the role of IP law in FinTech. To put it plainly, excuse me, please. The role of IP law in FinTech is to protect the value of intangible property, be it software or hardware, for the benefit of the creator. That essentially is the role of IP law in FinTech. And we've seen this play out in a number of cases from across the globe. I've listed some, but please note that this list is not exhaustible. There are so many other examples out there. The first case is the New York case of Hermes International and Hermes of Paris Incorporated versus Mason Rothschild, which centered on trademark of digital technology and compensation for abuse and unauthorized use of creation. So there we see it again. Someone's intellectual property is being protected by law, and rightfully so. The United States case of Samsung versus Apple, protection of innovations through patents. Recall from my earlier presentation, the earlier slide, that IP law also protects devices. And as you can see, that played out in court with Apple and Samsung. These are two major mobile phone manufacturers. We also have the USA case of Star Athletica, LCC, versus Varsity Brands Incorporated, which is protecting industrial design. The Italian case of Juventus FC versus Blockros, which was a case involving NFTs, non-fungible tokens. And here at home in Nigeria, we have the Nigerian case of Banire versus NTA, Star TV Network Limited, copyright protection, protection of goodwill and guarding against passing off. We also have the Nigerian case of Philip Morris brand SAL versus Benson and Hedges Overseas Limited. All in all, so far, we can see that the production of the mind or any creation of the mind adds value to man, adds value to society, and indeed adds value to nations. So look at the amount, the value of money that has been projected, 188 billion for the year 2024. And imagine if that entire 188 billion, I'm just saying, for example, was to be generated from Nigeria, as an example. It will no doubt add to our national bottom line. It will no doubt create jobs in Nigeria. It will no doubt improve consumer experience, enhance trade, and the likes. Therefore, why shouldn't the law protect those who have been gifted with the brilliant minds to create such applications, softwares, or hardware? Already, as it is in Nigeria, we have FinTech dominating in some market spaces. Here are some of the main market spaces in which FinTech dominates: digital payments, digital investments, digital capital raising, digital assets, and neobanking. As we all know, a few years ago, if you wanted to make any payment, you had to go into a branch, fill out a slip, and give it to the teller to effect payments. Likewise, if you wanted to make any investments, you had to go to the asset manager, fill out the form, write a check. This is not the case anymore. These days, with a simple app connected to your bank account or using your MasterCard, which is a payment gateway in itself, you can effect these transactions from the comfort of your living room. Similarly, from the comfort of your living room, you can buy digital assets using the appropriate applications. You can buy cryptocurrency, you can buy NFTs. Digital capital raising, you have them as well, crowdfunding and the likes. Neobanking, these days, banking services have been broadened with the use of FinTech applications. Gone are the days where you had to go into the branch again with your passport photograph and your proof of address and what have you, just to fill a form manually and just to open a bank account. And sometimes it was not instantaneous. You would still have to wait a couple of days, if not weeks, depending on which part of Nigeria you're situated in. These days, from the comfort of an armchair, you can easily open a bank account. This is the value of what FinTech enterprises have brought to Nigeria. Just to buttress my point, 383 Nigerian tech startups between 2015 and 2022 raised $2,068,709,445. That's a lot of money. Estimated total transaction value for 2023 is $58,037,000. Projected number of digital payment platforms by 2027 in Nigeria is 146 million users. I think if at all anything, our IP laws, particularly in the dispensation of justice, need to be enhanced so that this industry or sector is encouraged to thrive for the benefit of all concerned. IP regulation in Nigeria. So far, as a country and in comparison with other countries, we are not doing too badly with the laws we have regulating IP in Nigeria. We have the Nigerian Copyright Act 2022, which protects literary works, musical works, artistic works, cinematograph films, sound recordings, and broadcasts. We have the Trademark Act of 2004, and the name of a company, individual, or firm represented in a special or particular manner can be protected. The signature of the applicant for registration or some predecessor in his business can be protected. An invented word or invented words, any other distinctive mark. We also have the Patents and Design Act of 2004, which is designed to regulate the use of innovations or protect innovations for the benefit of the innovator. Inventive activity that is capable of industrial application, inventive activity that constitutes an improvement upon a patented invention. So these are the three primary laws that protect IP, that regulate IP in Nigeria. And that brings me to the end of my presentation.
Thank you very much, Mr. Albert, for a very comprehensive, in-depth presentation on the topic for today. Thank you very much once again. I will be calling on Mr. Polariwa Aluko to also give us his presentation before we take presentation from our mentees. Thank you very much, sir.
Thank you for having me on board.
If we have
Hi,
Mr. Polariwa.
Yes, I'm
Good
here.
afternoon, sir.
Hi, good afternoon. How are you doing?
We're fine, sir.
Nice.
Good afternoon.
Thanks, Mahadi, for what you're doing. I'd like to say, if you permit me, yes, I'll stay off video.
Okay, sir.
Yes, the conversation I think is a very practical one, and my intervention will also be a little short because, and I think one of the reasons why is because the conversation is still an ongoing one. It's a developing one, and if we're talking about the role of or the role intellectual property plays in the fintech space, I guess one would have to take a historical journey, and I think the conversation really centers around a good place to start will be um, a conception of what the traditional concept of property, is. Traditionally, we understand property to be, and by traditionally, I mean from a historical point of view, we understand property to be something physical that can be owned by a person. So it's a physical item that can be owned. Interestingly, not all jurisdictions, and that is in contemporary modern society now, not all jurisdictions recognize the right to own personal property. So that's something that we take for granted even in the 21st century, but it is the reality. There are jurisdictions that recognize the power of the state to, to over the right of the individual to own property, personal property. But from a historical point of view, property is something physical. And, if you go back to, as far back as possible to what is referred to as perhaps the first intellectual property law, that's the Statute of Anne, you'd still see that the there's a huge emphasis on the recognition of a person's physical property as property. So you see that idea, or you see the reflection of the thinking of the time that property is something physical that a person owns, or that a person has a right to. And if you take it back a few centuries to the Bill of Rights, I think that's one of the fundamental precepts of the Bill of Rights, is that individuals or human beings have the right to own property, and they have the right to own the product of their labor. So without going too far, that's a sense of the traditional concept of property. Now, why is this important? I think we find that in our economy or in our country today, we have not had the series of conversations that are necessary to bring us to a place where, people understand the nature of intellectual property. That's one of the reasons why conversations about intellectual property today are still either stunted or at an infantile or almost beginner stage generally. And that's because for most people, the concept of property is limited to the idea of something physical that you own. And so at some point in time, flowing from the Bill of Rights, and if you look at the writings of people like economists like Adam Smith, positivists like Jeremy Bentham, you will then see that there's a thread that flows that started to recognize the possibility that at some point ideas should be treated as property. And so the idea that an idea is property or has property value, is actually a fairly new one. Even though that is not to say that as ancient societies, whether it's in Africa or in Greece or in Rome, did not recognize the existence of an intangible universe, if you may. In African society, we recognize the intangible. And in some cases, we refer to intangibles as maybe our ancestors, or spirits, or whatever. But the idea that knowledge or ideas should be treated as property is a fairly new one. And to a large degree, it is Western in origin, especially the form that we practice in Nigeria, what we call intellectual property. It has Western origins. And so the decision that the state should give an idea the toga, or close an idea of the toga of property is fairly new. And of course, it has very large scale implications on everything. It actually changes the total meaning, and it has the possibility of changing society, and it has changed society, because moving forward now, the treatment of ideas as property actually led to what you may call the end of the industrial age and the dawn of the information age. And this is because traditionally ideas are not considered to be, property, but the property in intellectual property actually speaks to the value of the idea, and so it's based on that realization that the exertion of an individual on an idea, or an individual's ability to work an idea to extract value, or to extract something that is useful from an idea, should be treated as something that is valuable and should be protected. And of course, how do you protect your property? You protect your property by securing it, by doing everything you can to stop others from taking it from you, including, perhaps in some instances, even taking a life, in the protection of your life and property. So this idea that ideas are property, or the idea of ideas as property, very revolutionary, very radical, and had very significant impact on society. I'll give an example, and I'm just laying the foundation for the conversation on how IP affects the fintech industry. If you look at trademarks, we said the idea of ideas as property is new, and it actually originally started as a recognition that, if we're going back to statute of Anne, for example, a recognition that, okay, if anybody who prints or who writes should be properly recognized or cited as the author of that write-up. So it started with literary works. But then the envelope has been shifted from literary works. You then had artistic works. Even the definition of what consists of artistic works has also been gradually expanded, over the centuries and over the decades, to include something as, from something as simple as a painting or a scribble on a toilet paper or serviette paper, like the Picasso scribble or the Picasso drawing, to something as complex as an architectural design, and all these are referred to in the law as artistic work, to say, what do you call it, a photograph, and so on and so forth. So even within the different categories of works, there has been a steady expansion over the years. And so you have a growing class of works or sets of ideas or expressed ideas that are protected by law. And this protection comes in the form of some sort of monopoly right. So the right to stop others from doing certain things, and as I said, and so you have that on the one hand, and then at some level, there was a decision to also include words under the purview of, to treat words as property. And the decision to treat words as property has significant impact on society, because then you have free speech issues. You have issues of access to information, the right to communicate. You understand? So if a person owns a word, that means that person can control the business expression of that word, or how that word is expressed in a business community or in a business context, in the market. If I own Apple, I control the use of the word Apple in the market. Does that make sense? So this idea that ideas are property, of course, including words now and then, on and on to include inventions and things like that, has significant social and cultural implications. Look at, of course, many people grew up watching the movie Domitila, and there's such a hue and cry over the trademark. I don't think it's as important or as significant as people are making it out to be, but it is what it is. You had the Yoruba issue by Timbuktu Industries, who applied for a trademark who actually got a trademark at the UK IPO for the word Yoruba, and they were using that trademark to force other companies who wanted to use the word Yoruba, to purchase licenses from them, and so this idea that words or that ideas are property, or ideas have value, has large-scale implications on society, but coming down to, the fintech space, we're currently in the information age, and the shift from the industrial to the information age was primarily powered by ideas. And in fact, I think we're set to be in the fourth industrial revolution, which again, the bedrock of the fourth industrial revolution is information technology, the fusion, if you may, of digital, biological, physical worlds, the introduction of concepts such as artificial intelligence, cloud computing, robotics, IoT, etc., Web 3.0, into our daily lives. And so if we're in the era of ideas, or the era of information, and ideas are property, then that information has value, or the information is property as well. And so I would say that, I would argue, and it's a moot point, that the entire digital economy, if you may, is actually built on the foundation of intellectual property. So whether you're talking of whether you're talking in terms of protection, or you're talking in terms of the expanding the technological possibilities, you're talking in terms of even the visibility, so the branding, all built on the foundation of intellectual property. In Nigeria, I find that the fintech revolution, or the fintech wave, came a little late to Nigeria, as most things tend to. I think the fintech wave came to Nigeria about 2 years after it had already started outside the country, especially in Silicon Valley and in some parts of the West. And unfortunately, what has happened is that you have a lot of and so in Nigeria, one of the interesting things, which I don't think is not, it makes us unique. One of the things that makes us very unique is that the number of people who are unbanked is significantly and almost perilously high. And it has a lot to do with the type of the economy that we operate. So you had a situation where the commercial banks, and of course that includes all the mortgage banks, MFBs, and so on and so forth. But that primary institution did not serve, or was unable to serve the vast majority of Nigerians. So you had people in the so-called informal economy, according to CBN, who were handling cash transactions, but were handling cash transactions of a certain volume, individual volume, that could not be captured, or that was not worth the time of the banks, of our commercial banks. And so what then happens is you have a situation where once you introduce technology into that space, what happens is that, of course, technology makes things, has the capacity, and you reframe that, has the capacity to make things faster, to make things easier, to make things cheaper. And of course, it simplifies things easily. So what then happened was there was a huge adoption, because then you had fintech, you had companies, technology companies essentially, that started to think of, oh, how do we help those who don't have? Because with tech, the objective is, how do we achieve scale? How do we get a very large number of people? Again, it's a function of the information economy. In the information or in the digital economy, information is key. The primary resource is information. That's why, if I may digress very briefly, you have a company like WhatsApp that is not profitable, but that still exists, has a healthy financial outlook. Of course, one of the reasons is because they have the stock market in its country of operation is good. You know, they have a solid stock market. But you have a company like WhatsApp, you have a company like Twitter. Twitter has not made a profit since it was founded. I think this year under Elon Musk, they broke even. You know, Twitter had not made a profit. You have companies like Amazon that I think went the first 10 years before they made a profit. You know, so with tech, scale is the objective is scale, to achieve scale, you know, and to reach out to cover a very wide base, as wide a base as possible. So when that becomes the primary objective as opposed to profit, you know, and you have the ability to reach out to a very large number, to serve a large number of people almost instantaneously, what you have is, you know, magic, if you may. And so I would say that you then find that many of the companies, the tech startups that have become some of these quote unquote big fintech companies, and I represent a few fintech companies as well. And you find that many of them are actually very small operations. In fact, you'll find that some of them operate out of, even with the large amounts of venture capital funding, they operate out of tech hubs. You know, unfortunately, what I tend to find in Nigeria is that hello, Hussein, can you hear me?
Your voice went off, but we can hear you now.
Okay, I was saying that from the point of view of where did I go off? Where did you lose me?
You said you were talking about most of the tech companies with big venture capital only have tech, they operate on tech hub. So you were now
Oh
trying to
yes,
tell
I'll
us
say
what you.
that. Yes, many of them are actually, they are very lean, so very small staff strength. If you look at a company like Flutterwave, for example, 3 years ago, 4 years ago, Flutterwave was a relatively small company. Flutterwave grew in size significantly after they became a quote unquote unicorn. You know, and I think last year, in spite of their massive size, Flutterwave had about 300 to 400 employees globally for a company that big, you know, in terms of capitalization and in terms of impact, you know, across Africa. You know, so what that says to me is that, you know, technology has, you know, immense potential. But at the same time, if you still look at many of these fintech companies, because they're trying to operate on a very lean or I mean, talking about tech, unfortunately, some of these concessions found the founders either misunderstanding or failure to understand the value of the intellectual property. And that's why, talking about name brand, for example, you have Two-Face ended up changing their name, so similarities there. You see situations where plus
I'm
technology
sorry,
that,
sir. Your voice is
yes.
breaking. I think
How
your
is it now?
network. Okay, it's getting better now.
Okay, it's part of living in Nigeria. Power was just restored. I was on Gen, so we changed over to power. So I was saying that if you look at many of our fintech companies, so-called, the vast majority of them operate, again, it's still this same idea. Many of them, many tech people recognize the value of ideas, but don't recognize the importance of ideas as property, number one. Number two, many of our tech people, the framework for the delivery of this technology or of these services is built on, and again, it has to do with our infrastructural development. Many people use open source technology as the basis for their apps, the apps that they develop. And of course, that will have significant implications on proprietary use, on proprietary protection, and so on and so forth. Because the Patents and Designs Registry now awards or issues patents for what do you call these things? Business methods and utility models. The legality or otherwise is debatable, but at least the Patents and Designs Registry does that. And these things are available to many of our tech people. But then there's a question of what's the value in, in fact, it goes against the terms of use. If it's a GPU license, or if it's an open source, whatever type of open source, whether it's a Creative Commons license or whatever sort of license the software is based on. So there's that challenge as well. So circling back now to what the value of, let me just tie it all together, what the value of the role that intellectual property plays in the fintech space. Intellectual property is the foundation of the fintech space. Intellectual property law actually plays a pivotal role in setting the tone for the fintech revolution that we're experiencing today. Some of the challenges that we have are not really centered around the law, but they are centered around functions of history and perhaps development. What do I mean? I think maybe about 30 years ago, or 30 years ago or so, or 40 years ago, there was a decision that was made to make intellectual property the bread and butter of intellectual property lawyers. I think that was a bit of a mistake. And so you find that the people who talk about intellectual property are generally lawyers. And we all know that lawyers really, we are creative, but we are not the ones who need the information. The people who need the information are out there. So that's number one. Number two, as a result of that, you have a situation where many tech operations do not place a premium on the value of intellectual property, which is problematic because IP is what underpins or undergirds the entire industry. And then number three, as I had said earlier, many of the software that is deployed for a lot of our quote unquote fintech apps are actually built on, or they're based on open source or general purpose licenses, which have limitations. Well, I mean, they're good because it helps to spread knowledge, it helps to spread utility, but there are limitations on the sort of ownership or what one can claim in terms of ownership. So I think these are some of the major challenges that the space has faced. There are also regulatory challenges, but I guess that may be outside the purview of the conversation. So with that, I would say IP plays a very pivotal role in the fintech space. And I think one of the reasons why we've not seen the space move as fast as it can is because of some of the things we mentioned and how the space recognizes the value of IP. But I think that hopefully that will change, although there are signals that are foreshadowing some sort of financial crisis, and with all the things happening in with the venture capital funds, all the things happening with some of these banks, SVB and co, with the war in Ukraine, and with the recession, in some of the Western countries that venture capital comes from. There's a possibility that there might be some sort of wave coming. But I think IP really provides IP is a safe haven, for the creative minds in the tech industry to take advantage of. And with that, I think I'll bring my intervention to a close. Thank you very much.
Thank you very much, Mr. Folari Aluko. It has been very impactful and educative listening to the overview of the topic from you. Thank you very much. And also, Mr. Albert, thank you very much. We'll have only one presenter for the topic for today. So I'll be calling on the presenter to make his or her presentation for 10 minutes. I hope you are ready, presenter.
Yes, I am.
All right, thank you very much.
Good afternoon, everybody.
Good afternoon.
Yes, I'll be presenting on the topic of IP protection in FinTech. So the intersection, sorry, please excuse me. The intersection of finance and technology has led to the emergence of FinTech as a disruptive force in the financial service industry. So the FinTech innovations encompass a wide range of areas, including digital payments, blockchain technology, online lending platforms, and the likes. So as this innovation are gaining momentum and gaining traction, it becomes paramount for companies to operating within the FinTech sector to protect their products, to protect their intellectual property. So this presentation examines the topic of intellectual property protection in the FinTech industry. I'll start by defining intellectual property. Intellectual property, as defined by WIPO, refers to the creation of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce, etc., and so on. The importance of intellectual property in FinTech cannot be understated because it plays a crucial role in fostering innovation and making sure that technology, the fintech technology becomes better and better. An effective intellectual property strategy enables fintech companies to secure that technological advancement, to maintain market share, attract investors, and establish barrier to entry for potential competitors. So without intellectual property of these products, of these fintech products, there will be a loss of market share, diminishing return on investment, and products that are being created would not be up to standard. So what are the key aspects of intellectual property in fintech? First, we have the trademark. The trademark is a sign capable of distinguishing the products or services of one enterprise from other enterprises. So trademark dates back to ancient times when artisans used to put their signature or mark on their products. So the trademark in the fintech industry would be their unique logo, their brand names, their slogans, and their trademark registration, which prevents others from using those marks, and so that it will not cause confusion between it will not cause confusions for the consumers, and then there will be fair competition between other fintech companies. Things like domain name icons, for example, are used to identify some of these fintech companies. Like the Flutterwave logo and the Paystack logo are definitely not the same, and with that, we're able to distinguish between the two fintech companies. Another aspect is copyright. Copyright is a legal term used to describe the rights a creator have over their literary and artistic work. Works covered by copyright range from books, movies, paintings, and to computer programs in the case of fintech, databases, advertisements, maps, and technical drawings. So copyright protection can be utilized to safeguard fintech software, source code, and creative content. While copyright may not essentially protect the idea or the concept of a particular fintech product, it offers protection of the expression of that idea in a tangible form, such as like I've already stated, the software code, the design, and the user interface. Next aspect is the patent. A patent is an exclusive right granted for an invention. The patent provides the patent owner with the right to decide how or whether the invention can be used by other people. In exchange for this right, the patent owners makes technical information about the invention publicly available in the patent documents. So patents are valuable tools for protecting fintech inventions. They provide exclusive rights to the inventors and prevent others from using, making, and selling that technology, that patented technology without authorization. So patents offers a strong defense against imitation and serves as a deterrent to potential infringers. Patent is an exclusive right, as I've already stated, that protects that invention from being replicated or being imitated by other persons. And usually there's a limit of 20 years on the patent. So it gives fintech companies the right to exploit their innovation and their invention exclusively for themselves. Next aspect is trade secrets. Trade secrets are intellectual property rights on confidential information, which may be sold or licensed. The unauthorized acquisition, use, or disclosure of such secret information in a manner contrary to honest commercial practice by others is regarded as an unfair practice and a violation of the trade secrets. Value of an organization is beyond the trade secrets, but at the same time, there's value in the trade secrets. It's what they use to make money, and what other people have what they have that other people don't have. So fintech companies can rely on trade secrets protection to safeguard confidential business information, vital business information, to protect their algorithm. Like now, maybe the AI they use, the AI algorithm they use in ensuring customer retention or making sales. So they have the right to protect that information and to protect that algorithm. They also have the right to protect their customer database. Customer data is a very sensitive thing, and it's always best to be able to keep it safe from other persons. So maintaining a secrecy of the trade, maintaining trade secrets is very, very important to the growth of fintech companies. So for a company's information to qualify as a trade secret, it must be commercially valuable. So fintech, a trade secret for fintech could include the backend server processes, the business idea, like I've said, and the code that they use to create their products. So a good way of ensuring these trade secrets are protected is through NDAs, that's non-disclosure agreements with employees, partners, investors, clients, and the likes. Industrial design. Industrial design constitutes the ornamental or artistic aspect of an article. Design may consist of three-dimensional features such as the shape or surface of an article, or two-dimensional features such as the pattern, lines, or color. So we see this very often with fintech apps. They are UI design, and it's always best to protect and differentiate between the UI designs of one company and another company so that there will not be confusion for the consumers or the customers. So I would like to talk about an effective intellectual property protection strategy. So the first strategy is a proactive intellectual property management. So establishing a comprehensive IP strategy that aligns with business goals and continuously monitoring the competitive landscape for potential infringement. So they should have like people that constantly look at constantly monitor their intellectual property and see whether other people are not copying their own intellectual property. And so there's the collaboration and partnership. So collaborating with other industry players and strategic partners to pool resources, share knowledge, and jointly protect intellectual property assets. So there's the patent portfolio development tool. So building a robust patent portfolio that covers core innovations and technological advancements, so as to stop competitors from recreating their own products and then to create a barrier to entry. And then the international IP protection. So expanding IP protection beyond domestic borders through international patents filing, trademark registration, and compliance with regional IP laws. So in that way, they are able to not just stop Nigerian competitors from using their products, or not just to protect their products from Nigerian competitions, but also from international competitors. So yeah, thank you. That is the end of my presentation.
Thank you very much, Oluwakamiko Sanyu. Kindly join me in thanking him and telling him a job well done. That's for the group members and the mentees on the call. We'll be taking comments and corrections from our mentors. Any comments on the PowerPoint presentation that was presented by Oluwakamiko? So we'll be taking it. Okay, I'll call on Mr. Albert if you have any comments or contribution on the PowerPoint slides.
Well, I'd like to commend the presenter for a very nice presentation. I think he covered very broadly the subject matter. Well done.
Thank you, sir.
I'll also call on Mr. Folari to also give his comments on the PowerPoint presentation.
Yeah, well done. fantastic, what's it called, presentation. I understand both topics are actually very wide. And so it's, I can imagine it should take a lot of effort within, although I'm not sure how much time you guys had to prepare, but, putting your thoughts together and, articulating it, especially if you're working as a group, will take some time. I would quickly mention that what I find, I think we should, if we're having conversations about IP, and fintech, that's why I try to make my intervention, more than just the usual. Oh, there's trademarks, there's copyrights, there's patents, there's designs. You understand? So I think you guys can go deeper into the concepts of innovation. I think we should start to have much deeper conversations about these things. And I think this platform is a very powerful one. In the past, I've been part of several very interesting conversations, and today's has been equally interesting. So I would encourage you to dig a little deeper, and let's see what type of conversations we can have, beyond the usual, there's copyrights, there's patents, there's trademark, there's trade secrets. Those are all surface level. I think to some degree, they're surface level conversation, but I understand that for the purpose of this intervention, you may have been required to look primarily at these forms of intellectual property protection. But it will be very helpful to dig a little deeper. I'll give for instance, in every economy, there's a sector that drives innovation. Speaking from an innovation point of view, in Nigeria, the sector that drives innovation is the financial industry. In the US, it is the gaming industry that drives innovation. And if you look at from slot machines to video games, it's the gaming industry that is primarily responsible for the modern microchip, for the innovations in virtual reality, vision, big screens, TVs, and all of that. So the gaming industry drives innovation. In the US, for example, in Nigeria, it's the financial services industry, and you can see that just from the type and the sophistication and the nature of technology that we use. Let's discount the unfortunate events of the most recent CBN policy, and all of that. But you find that things like the ATM, this our PIN technology or card PIN technology was primarily driven by the financial services industry. And of course, data security, network security, all those things were driven by the financial services industry. So because the financial services industry in Nigeria drives, so most innovation is first introduced in that space before it generally tends to come or seep into other parts of the country. So I would say that that makes any conversation about financial tech, very, very interesting. Has the potential in Nigeria to be very interesting. And I think the last thought I'll leave you guys with will be that on this point, at its roots, every service in the digital economy is a financial service. Every service is a financial service. If you buy, some years ago, I had a conversation with a friend of mine, and I told him that I could do a transaction with credit, with mobile recharge credit. And so it was several years ago. I think we boarded a taxi, and when we arrived at our destination, I asked the taxi driver if he would accept a recharge card as payment. And he agreed, you know. So if you think about it, the quote unquote, the credit that we buy, you know, is fungible to a degree because everybody will use credit. What do you call it? Data also has some level of fungibility because we live in the information age, in the digital economy. Data, people were shouting during COVID, no money, no money, no money. And they were shouting on Twitter. And I'm asking myself, which data did you use to enter Twitter? You know, so these things are fungible. So every service at its root really is a financial service. You know, I won't dig deeper into that. Maybe anyone who is interested in driving that, exploring that conversation forward, I'd be happy to have a private conversation with you on that, so that we don't derail today's talk. But at its roots, every service in the digital economy is a financial service. So I think we should have deeper conversations about these concepts. It will help. It will seep into the mainstream. It will help strengthen regulation, and it will also help strengthen the implementation or the creation of services to reach those people who need the services. All in all, well done, guys. Thank you.
All right, thank you very much, Mr. Folari and Mr. Alex, for the comments on the presentation. So quickly, before we move on to the question and answer session, we'll be taking screenshots. So I encourage everyone to put on their videos, the mentees and the mentor, if possible. Put on your video while I take screenshots of our beautiful faces and handsome faces for 30 seconds before we move on to the question and answer. Thank you very much. Okay, thank you very much. As you do so. Okay. Okay, so I've taken some screenshots and I'll be taking the questions now. But before the questions, I'll be asking our mentees on the call if they have any live question. You can quickly, you can just raise your hand while I call on you to ask your question. If you have any live question, just raise your hand and I'll call on you to ask your question. And I'll also be posting the questions on the chat box for everyone to see. So the first question is for Mr. Folarinwa. Where a particular fintech company has gained goodwill over the use of a particular trademark but does not register, and a fintech startup that has came up into the market registers the trademark. How can the fintech company who has gained the goodwill of people avail itself? Mr. Folarinwa, did you get the question?
Yes, I did. Sorry, we live in Nigeria, so we know how it is. So where a particular fintech has gained, so it's essentially a goodwill question. Where a particular fintech company has gained goodwill over the years, over using a particular brand, which is not registered, and a fintech startup. So the first question I'll probably ask is, when you say using a particular trademark but does not register, that registration, are we talking about what's the nature of that registration? Are we talking trademark registration? Are we talking registration with the regulatory body?
Yes. Trademark registration.
So the interesting thing is, the point I was trying to make was that before you can register, let's say, I think someone's my kids. So let's say that before, if it's a fintech company that wishes to, maybe their pathway to providing this financial service is through, maybe they've been bullied by the CBN to obtain an MFB license or some sort of other license. CBN generally would require that certain preliminary steps should be taken to address branding issues. So the company must register, for example, and get with CAC. The CBN doesn't insist on trademark registration as at yet. But since this is a goodwill conversation, it's a general, I think I highlighted the CUDA and the CUDI issue. And I was somewhat hoping that we would get a very good set of disputes from that interaction, but well, fortunately, because I felt that the dispute would enrich, jurisprudence. But what then happened was one of them decided, you know what, let's change our name. And so they rebranded as Number. But in such a situation, think of it as an Apple Samsung scenario. What the average company might want to do would be to use their IP to obtain a dominant market position. And so and that's really what many companies, that's the IP strategy for most traditional brands. You use your intellectual property to solidify your position, to control the market, to hold a dominant position in the market. So I would say my answer would be, for the trademark registry, I think there are provisions under which the true owner can apply. In fact, in Nigeria, trademarks are registered under, there's a premise, a good faith premise, that a mark is being registered in good faith. So once an applicant or once somebody shows that the mark was not registered in good faith by the true proprietor or manufacturer, there are reliefs available to such a proprietor or manufacturer. So the pathway will definitely be will be adversarial, either through a petition to the trademark registrar or through a cease and desist letter. But considering that in this scenario, the newer company has registered the trademark, so you could apply for rectification. You could file a suit directly at the Federal High Court. Although the suit at the Federal High Court would not be for trademark infringement, because trademark infringement is a remedy that is only applicable to a party who has a registered trademark, who owns a registered trademark. But one can apply to the Federal High Court for any of the rectification reliefs, or for an order to compel the trademarks registrar to strike off or to expunge the trademark from the register, and so on and so forth. So there are legal reliefs. And these days, there's also the growth of mediation and arbitration. So ADR is a growing pathway, to settle IP disputes because of the time-sensitive nature of many of these disputes. So at the moment, the fintech space is very gray, because you have insurance, it is gray in terms of regulation. Although the CBN has tried to dominate the market, which is wrong, because it really, you have CBN laying down, first of all, they're very lazy. And then second of all, the Nigerian factor, the regulator just gives a one-size-fits-all regulation and says, all companies. So you have an Aboki FX that only deals in information, suffering from account closure, or policies that affect companies that provide Bitcoin, that are operate as Bitcoin exchanges, or operate as the crypto exchanges, or or whatever. That's it. It's most unfortunate. But so regulation is gray in terms of what the law really allows if we were to test it in court. So you cannot have a dispute resolution mechanism on that scale. But what I would say is that the parties can seek some sort of mediation, some sort of ADR. That's also a major pathway for resolving IP disputes. But a lot of damage can be inflicted, and because in the fintech space, you're using tech, most likely the point of interaction might be through an app. And there are a number of app markets, but there are, I think, two major app markets. You have the iOS market and the Android market. So having two apps with similar names, in the same market can be problematic. And of course, somebody will suffer damage or injury. So I hope I have answered that question fairly well.
Thank you very much, Mr. Folari, for the answer to that question. I can see a mentee's hand is raised, so I will give her the opportunity to ask her question. Sally Woliat.
Thank you, sir, and Mr. Folari and Mr. Albert for the mentorship session. My question is that who owns the IP rights in the fintech, like in the technology itself, when there is a collaboration between the fintech and a financial institution? That's my question.
Okay, I think Mr. Albert can go first on the answer.
Yes, thank you, Saliat, for your question. In my experience, we find that when parties collaborate, or we tend to advise that they enter into a collaboration agreement. One of the importance of this type of agreement is, first and foremost, it defines the scope of the collaboration. And then, more to your question, it defines or determines who owns the rights. Now, collaboration in practice varies. When you say collaborate, what you're just saying is, what are you bringing to the table? If I'm the technical guy, I'm going to do the software development and what have you, and you are the money guy bringing the money, then how do we share the proceeds? Let us agree. If we say 60-40, 70-30, whatever we agree, you tend to create that and capture that under an SPV, which is a special purpose vehicle. It's a company that you register with, both of you as shareholders, or both parties as shareholders, and the shares will determine your, sharing formula, or your sharing formula will determine your shareholding. So if you say 1 million naira share capital company, obviously someone will get 700,000 and the other person will get 300,000. And that is essentially how it is done in practice as we advise it. Yes. Now, where people do not use a collaboration agreement and then they register the trademark in the name of the entity that is going to be trading, what you now find is they go to court. And then it's now a function of providing evidence as to whose idea it originally was, if you understand what I mean, and who should get paid for that. I think there was a case in the US regarding NFTs, and it had to do with was it one of the ape NFTs? And they actually had to go to court and show emails and show jottings, concepts, ideas that were exchanged, screenshots of messages exchanged for the court to determine who actually owned that idea. But the cleaner and safer way is what I have just described, for parties to enter a collaboration agreement. Part of that collaboration agreement will see the establishment of an SPV, and then the shareholding, and then the registration of the intellectual property, either trademark, copyright, whatever, in the name of that SPV. I hope that answers your question.
All right, thank you very much, Mr. Albert.
Yes, sir.
I will
Thank
also
you, sir.
give the floor to Mr. Folari to contribute to the question. Mr. Folari.
Okay. Yes. So interesting question. Let me take a different route. I think so. The question is, how do you protect your innovation when you're collaborating with? I think the question had to do with, you have a fintech company collaborating with a bank. Most times, yes, that particular scenario, that relationship evolves because somebody wants to, I forget the term that is used, but to share a license or to take advantage of a regulatory license. And in that scenario, just as Mr. Albert said, what you just do is you recognize that clearly somebody's role is in the form of providing access to a license. So when it comes to ownership of the tech, the tech component in the fintech dynamic, I don't think it would be, yes, I guess it depends on the nature of the transaction and nature of negotiation, but it may just happen that the fin or the license holder may want a piece of the pie, a piece to own a piece of or to be listed as a co-owner with regards to of the software or the tech part. I think it might not be a good idea for a fintech company or a tech company that seeks to offer financial services to wait until they're partnering with a third party before they do before they start the process of protecting their brands. Does that make sense? So the first thing that the company has to do, or that the tech company or the startup should do, is ensure that I said brand, is ensure that their intellectual property is protected. So if it's physical technology, if it's an invention, you obtain your patent. If it's and even if it is software, I mean, why not apply for a patent for that? Even though we know that software is traditionally protected by copyright as literary work, because the code is written, it's literary. But for what it's worth, it may just hold up, your patent may hold up in court. So, but the idea is you should protect your intellectual property. My main concern really centers around, as I had mentioned in my opening, around the fact that a lot of the development that we have today, you see people using C++ and Python and other languages. A lot of this development really is centered around, or is built on the foundation of open source software. And the problem is that open source licenses they're restrictive because, I mean, it was given to you for free, or you were given access to the code for free. And so there are limitations on how you use that code, or how you can protect the code or monopolize that code. So I would like to see a situation where, as is common in some other parts of the world, where developers actually build from scratch. Then you can have something that, of course, the novelty, open source software would defeat any novelty requirements if there were to be such a test, if we were put to such a test. So I think for me, my intervention would be more along the lines of, how do we ensure that our people are really building innovative technology, that will stand the test of any material challenge in Nigeria or abroad. And I understand that recently a Nigerian patent a software patent was recently, I think last year, was accepted for registration at WIPO's International Bureau. So it passed all the substantive examination, and so on and so forth. So, somewhat validating what the patent application, validating the grant of the patent by the Patent and Designs Registry. So I would say the best approach should be, if you're a tech company, protect your IP first, ensure that your IP is protected before you seek to collaborate. And when collaborating, you have to spell the punishment must fit the crime. So whatever any partner is taking, a partner who comes in post fact, whatever they are demanding must match whatever it is that they're bringing, and that's the other side where many fintech entrepreneurs might not have the tools to negotiate these outcomes. I've seen so many situations where, people make bad decisions. You have somebody who is giving out shares, in the company and says, okay, because most times you find venture capital firms would require that, certain percentages should be given to different players in the operation. And so you find people just allocating shares or allotting shares to at random to people, and it creates problems down the road, and of course, anyway, but specifically to the question, I would say protect your IP first before you look to partner, and then when negotiating these deals, ensure that the punishment fits the crime. So whatever that person is asking for must match the value that they are bringing. These days, license sharing, I think banks like Globus, Titan, and a couple of other banks, there are quite a number of banks that are willing to sit down with fintech companies to discuss, license sharing. So it's not a monopoly anymore. So there's no that unequal bargaining position. It's still fairly unequal, but it's not equal. But at least there are more options available to tech startups.
Thank you very much, Mr. Albert and Aluko. I'll be reading out this question. I'm still waiting for the mentees that have live questions. This question is for Mr. Albert. What are the common challenges that fintech companies face when it comes to protecting their intellectual property?
I think when you look at it, I would broadly say decision making. Before you even get to protection of intellectual property, fintech companies behind the scenes, because of the lean structure they operate, tend to first and foremost take their time in deciding who gets what in terms of, just what would seemingly be a random allocation of shares. And eventually when they get that act together, when they get the product out, then they think of intellectual property. By that time, is it possibly too late? And if yes, then, is there any remedy available? Of course, they can always change the name, but then if they've gone far down the road, one will have to investigate how such a name can still be obtained for them from the registry. Where it is not possible, then simply they just have to pick another name. Other than that, off the top of my head, what I can just think of is the usual delays at the registry. Now I'm talking of in practical terms, of registration of trademarks or your copyright and the likes. So it's more of a bureaucratic one. Thank you.
Thank you very much, Mr. Albert. I'll be reading the next question for Mr. Folari Aluko. Are there any regulations or laws specific to fintechs that governs intellectual property?
Are there industry specific IP regulations for first of all, I think it might be difficult to define the scope of, or to narrowly define the scope of fintech, as one homogeneous, as applying to a homogeneous sector. Within the, you can suppose argue there are 4 broad types of fintech companies, or at a very general level or generic level, you can have maybe 5 broad types. But I think, like I was saying, every service is a potential financial service. Think of a rideshare app, for example, like Taxify. That's the name of, Taxify, or Uber, let's say Uber. Imagine that Uber had a wallet function, and they do have a wallet function. You can put money on your Uber app, and then, but it's a rideshare app, yeah? You put money on your Uber, and then you pay from your wallet when you drive, or when at the end of your ride. Imagine that wallets now become transferable. That, one user can talk to another user, or one device can talk to another device, they can, and so I can send money from my wallet to another person. What you've essentially done is you've created a financial service, because I can walk into a market, for example, and ask the seller, oh, do you have Uber? Do you Uber? The person says yes. I say, oh, I don't have cash here. Can I pay with Uber coins, Uber coin, or whatever? You understand? So you have a rideshare app that has become, has become a finance app. The same way people use gift cards to perpetuate financial fraud. You say, oh, a gift card is a loyalty item that is given by stores and supermarkets. How then does it become a conduit for financial fraud? So every service. So there's no one regulation. And that's one of the challenges facing. It's not a challenge, but it's one of the realities across the world that fintech proprietors and even tech proprietors generally are facing. And the reality is that there's no one size fits all. You can't put fintech companies into one box or one bracket. So I would say that that's a long answer. The short answer is that the same intellectual property laws that apply to every other industry also apply to tech companies, but to fintech companies. But because fintech companies have at least the tech side, is usually centered around an app. So that's software. Of course, you're looking at the primary IP rights that protects software, copyright, and then if you are of the adventurous persuasion, you can say patents. So you can decide to use the utility model or business method that the registry, Patents and Designs Registry, is offering. Then of course, so that's for the tech part. Then you can now look at the branding, and so on and so forth. So trademarks. I don't personally believe that trade secrets are intellectual property in the sense that the word trade secret is descriptive. It's not prescriptive. It describes any number of things from a formula to an invention. It doesn't speak to the nature of the secret. I think it's more of an industrial tool as opposed to an intellectual property category, because anything can be a secret. My relationship with Hussein can be the trade secret. It might be an invention, whatever. But I would say, to specifically answer the question, there's no one set of regulations that apply to fintech companies when it comes to IP. But it's the same. They have an IP. IP actually is property and you have rights that, you have rights over your property. So you shouldn't think of it in terms of what regulations are specific. You should think in terms of what rights do fintech companies have over their intellectual property. I think that's a more holistic way to look at the question. So yeah, I hope that clarifies that.
All right, thank you very much, Mr. Folari. The next question is for Mr. Alex. Mr. Albert, how do patents apply to fintech innovations?
Thank you very much. So when we understand the law of patents, what you are patenting actually is a design. So to put it in practical terms, anyone that has a phone, Android or an iOS phone, the shape and functionality of that handheld device, that phone, is what you can patent. Okay, the specification and the likes. Okay, it cannot apply to your logo or your source code, as you are. Those will be trademark and copyright. So patents have to do with things that will, in fintech, generally described as hardware. Your server, you notice that different server manufacturers have different types of servers, and they vary. They may all share the same capacity, but in terms of speed and what have you, other technical specifications, they vary. And those are exactly the type of things that would come under, the Patent and Industry Design Act. I hope I've been able to answer your question.
Thank you very much, Mr. Albert. The next question for Mr. Folari. What are the potential risks associated with someone else intellect in the fintech space?
What are the risks? I think the risks.
I think it's
yes.
It should be penalties, risks and penalties.
Okay. Well, I mean, it should still be the same set of risks and penalties that would apply in almost any other industry. So infringing on a trademark, a registered trademark, of course, or even so, it's let's just group it into. There's a possibility of what are the remedies? I think that would be a good way to look at it. The IP owner can obtain some injunctive remedies against an infringer. There's a remedy called the accounts for profits. So an infringing company or somebody who is found to be, this is at the conclusion of trial, someone is found to be infringing, that person may be compelled to account for any profits made in the exploitation of that intellectual property. So if you made money, so much money, X amount, then that will be taken from and given to the owner. Then in some specific cases, the courts are empowered, I think it was section 15, 16, I'm not sure, of the Copyright Act, to look at, to grant exemplary damages based on certain factors, the flagrancy of the infringement, the extent of the infringement, aggravating factors, if you may. The court can say, okay, we'll grant exemplary damages. And of course, in this digital space, cancellation, I would believe, is a major reality because the probability that a social media call out would happen and it would trigger some sort of cancellation, you find that being one way through which disputes are resolved. You can think of it as a digital mob, and I think it's, of course, nowadays, sometimes, not all the time, sometimes people would want to hear from the other side, but it's still, mob action. And most times the other person may be cancelled before the facts come out. So I would say that. And then, of course, there are those who, I hear people now use EFCC to pursue trademark infringement, copyright infringement matters. So there are the criminal aspects to, if you look at the Merchandise Marks Act, there are sections of the Copyright Act and both the Trademarks and the Patents and Designs Act that contain that criminalize certain actions that are considered that are infringing in nature. So in terms of what the penalties are, it's a panoply of possible penalties, if I may alliterate the P. So you have, of course, liability to civil litigation, liability to criminal litigation, accounts for profit, damages, of course, plus exemplary damages. Then you have, I think there are conversion rights under the Copyright Act. So any machines that were used to create or to multiply or to infringe can be taken and applied to or given to the person whose works were infringed or destroyed, depending on the nature of the order. So I think it's the same set of penalties that apply across board. So there's no special case for FinTech infringement in the FinTech space. Maybe God will also punish the person if the case is taken to a church or to a mosque or to traditional center. Yeah,
thank you very much. Yeah, thank you very much, Mr. Felari, for the answer to that question. I'll be taking the last question, and both mentors will contribute in taking the answer. The last question is: are there any recent developments or trends in FinTech and intellectual property that companies should be aware of? Mr. Albert can go first. Mr. Albert.
In terms of recent developments, I think the one that comes to mind had nothing to do with FinTech. It was a domiciliar case, and where someone had rushed off to trademark the name, even though that person might have found out was not the creator. And the registry, the tribunal looked into it and vacated registration that was given to that person. So what that tells you in the FinTech space is, even though someone might have rushed off to register your brand, and I wouldn't advise it anyway. I think you should always register as soon as you, even if possible, before you set the ball rolling, you should register your intellectual property. It's very essential, preferably before even you commence operation. But if you find that that is not the situation with you, perhaps you might even get reprieve where the facts of your matter are compelling enough for the registry to vacate any such registration. So off the top of my head, that is what comes to mind. Thank you.
Thank you very much, Mr. Albert. The same question will be referred to Mr. Larry.
Okay. So I think in terms of recent developments, of course, so it's fintech, so there are financial development. Nigeria has been in a recession since forever. And I look back to the CBN policy, the Naira withdrawal policy, and how that, what happened was that many people who were previously unbanked, tried to get into the formal financial sector. And that put a huge strain and stress on the formal financial sector, on the technology that we had come to rely on, and I think it broke the technology. And so what that did was I know that the fintech companies were the biggest beneficiaries from that, particularly OPay. Now everybody and their sister has an OPay account. Everybody and their mother, as colloquially said. So that has had a huge impact to push people. I think Kuda branch, they've all had a huge impact. I think also the fact that deposit money banks, the commercial banks, don't provide loans to the people who need the loans. So the loans are generally provided. So what you have is a situation where these fintech companies that are heavy on working capital or operational funding can afford to give out loans at lower rates than the approved CBN or monetary rates. But then, of course, without the bottlenecks of what do you call it? So essentially money lenders, and you have that situation. And then what tends to happen is that the people who lend are at the mercy of the money lenders. That led to the Competition and Consumer Protection Council stepping in. I like how the CPC was renamed. It was turned to the Federal Competition and Consumer Protection Council. So it means that you can have a state Competition and Consumer Protection Council. But anyway, that's a digression. So FCCPC stepped in, but I think they took a wrong step by trying to become a regulator. The FCCPC is an ombudsman, like a dispute resolver that resolves disputes on a case-by-case basis. But they now came out as some sort of regulator and issued licenses. And unfortunately, many of these fintech companies started to jump on it to apply for licenses, unfortunately. But a recent development is that service has been stopped. So there's no need. I think at some point they even published the list of compliant deposit money companies. No, they call them online digital lenders or something like that. That has stopped. So you don't need to apply to the FCCPC for a license to operate. Ordinarily, money lending is within the purview of the state. It's a state. The state has so the federal government under any auspices does not have the power to regulate. So there's that. I think importantly also, I had mentioned that the Patents and Designs Registry, according to the registrar, the chief registrar, Mrs. Stella Izenduka, has started issuing business method patents for software inventions. Now they're called computer-generated invention. And even if you look at cases like Bilski, like 2012, 2007, 2008 cases from the US, where the grant of patents for software was recognized and then de-recognized by the US, by a state Supreme Court. I don't recall now, but the case is Bilski for anyone who wants to read up on it. You find that this question of granting patents for computer-generated inventions or software-based inventions, is not something new. In fact, I think the Japan Patents Act specifically provides for it. In Nigeria, the Patents and the Patents and Designs Act contains, it expressly excludes certain matter from patentability. And of course, if you use the exclusionary principle of interpretation, so the exclusion of one thing, or the specific exclusion of one thing, or the specific mention of one thing implies the exclusion of every other thing, you know. So if you reverse that, what it means is that what is not expressly excluded is impliedly, can be impliedly included. Especially if you now look at section 4 that now tells you, talks about substantive compliance with the Act. So once you've complied with the substantive provisions of the Act, you've filed your Form 1, your Form 3, your specifications, your claims, you know, and all of that. Once you've done that, the registrar must issue a patent. The problem is that our patents are only issued at the risk of the patentee without any guarantee as to validity, which is a problem, because if you look at South Africa, South Africa also has a no examination rule, but a patent certificate in South Africa is prima facie evidence of validity. You know, so I would say this business method, I mean, a business method has a shorter shelf life than a registered patent. Again, the validity is different. I think if you're going to grant a patent for software-based invention, it should enjoy the full 20 years, renewable on a yearly basis. But the registry, utility models, I think 10 years, the business methods, 7 years or something like that. So that's, it's an added, you can consider it to be an added option for protection for fintech companies. But again, my challenge is that many fintech companies use open source software, and some of the express terms of these licenses is that you cannot obtain a patent or obtain some kind of monopoly over the software. Yeah, so yeah, these are just some of the recent developments on the top of my head.
Thank you very much to our both mentors for the session today. We've learned a lot. It's very impactful and educative. And thank you also for providing answers to our question. Finally, I'll be asking one more time for questions from our mentees. Any live question regarding the topic, anything, and you want, encourage that you raise your hand and I'll call on you to ask your question. Okay, I can't see any hand raised. With this, we've come to the end of the session for today. Thank you very much to our presenter for today, and also to the group for a job well done. So with this, I'll say, have a lovely and wonderful weekend to everyone, and bye-bye. Thank you very much, Mr. Folarin Aluko. It was nice to have you here today, and also Mr. Albert. Thank you very much.
Thank you very much, Mahadi. It was a pleasure. And thanks to all participants and Mr. Albert for interesting conversation.
Thank you very much.
Thank you very much.
Right, goodbye, everyone.
Thank you very much, Mr. Folarin Aluko. It was a pleasure meeting you and sharing this platform with you. Thank you very much to all the mentees for listening to what we had to share with you. And thank you for your very interesting questions. We wish you all the best. Bye-bye.
Thank you very much. Bye.